What?
We don't have a, for a pointer, we wouldn't happen to have just like a wooden.
Heavy yards.
I know,
That would be
wait,
perfect
there's
for you.
one,
Do you have one, Lynn?
No, I used to. I think there's one in the corner of my office.
You want me to run check?
Yeah, you can check. I think
Says
it
that
might
that been somewhere down
be.
there.
It'd be like where I put my flowers and stuff. I know I
Okay.
used one here. Only way I can get the papers from
And then,
my desk, you know, that you drop.
Oh.
behind county board, behind
I
that
do
branch,
that.
they have a AV room back there, and there's a
Probably is a plane.
tripod,
Since the jury isn't down here yet. I think I put it.
chalkboard on one side and paper easel. And they have a pointer thing on there, but I don't have keys for that anymore. Are you gonna use the screen?
Yes. Enjoying this.
All right,
Yeah.
so you're gonna be moving around, you're telling me?
I'll stand and then just point to
I
something.
just wanna know, so, once I point the camera at you and I give you the screen, I can't move it anymore.
Gotcha.
No.
That's right.
Right, jury? You may be seated.
Ladies and gentlemen, we're at the time we have to close those books. Can't open them up again until you begin your deliberations. And we'll now start with the jury instructions. Members of the jury, the court will now instruct you upon the principles of law which you are to follow in considering the evidence and reaching your verdict. It is your duty to follow all of these instructions. Regardless of any opinion you have or what the law is or ought to be, you must base your verdict on the law giving you these instructions. And these instructions alone reach your verdict. If any member of the jury has an impression of my opinion as to whether the defendant is guilty or not guilty, disregard that impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the sole judges of the facts. The court is the judge of the law only. First cover the information charges that on or about Tuesday, August 4th, 2020, in the city of Oshkosh, Winnebago County, Wisconsin, Joshua W. Aide did cause the death of James Gruettner with intent to kill that person contrary to Wisconsin statutes. To this charge, the defendant has entered a plea of not guilty, which means that the state must prove every element of the offense charged beyond a reasonable doubt. First-degree intentional homicide, as defined in Section 940.01 of the Criminal Code of Wisconsin, is committed by one who caused the death of another human being with the intent to cause that person or another. Before you may find the defendant guilty of first-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements are present. Number one, the defendant caused the death of James Gruettner. Cause means that the defendant's act was a substantial factor in producing the death. Number two, the defendant acted with intent to kill James Gruettner. Intent to kill means that the defendant had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. While the law requires the defendant acted with intent to kill, it does not require that the intent existed for any particular length of time before the act is committed. The act need not be brooded over, considered, reflected upon for a week, a day, an hour, or even a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be found at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, that the law of the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as circumstance to aid in establishing the guilt of the defendant, the state is not required to prove motive on the part of the defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances. Self-defense is an issue in this case. The law of self-defense allows the defendant to threaten or intentionally use force against another only if the defendant believes that there was an actual or imminent unlawful interference with the defendant's person and the defendant believed that the amount of force the defendant used or threatened to use was necessary to prevent or terminate the interference, and the defendant's belief was reasonable. The defendant may intentionally use force which is intended or likely to cause death or great bodily harm only if the defendant reasonably believed that the force used was necessary to prevent imminent death or great bodily harm to himself. A belief may be reasonable even though mistaken. In determining whether the defendant's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances at the time of the alleged offense. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time the defendant acts and not from the viewpoint of the jury now. The state must prove by evidence which satisfies you beyond a reasonable doubt that the defendant did not act lawfully in self-defense. If you are satisfied beyond a reasonable doubt that both elements of first-degree intentional homicide have been proved and that the defendant did not act lawfully in self-defense, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. The second and third counts of the information charge that on or about Tuesday, August 4th, 2020, in the city of Oshkosh, Winnebago County, Wisconsin, Joshua W. Aide attempted to cause the deaths of John F. Miller and Rebecca Borkowski with intent to kill each of them respectively, contrary to Wisconsin statutes. To these charges, the defendant has entered pleas of not guilty, which means that the state must prove every element of the offense charged beyond a reasonable doubt. The defendant is charged in charged with 2 counts of attempted first-degree intentional homicide. The crime of attempted first-degree intentional homicide is defined in sections 939.32 and 940.01 of the Criminal Code of Wisconsin, is committed by one who, with intent to commit first-degree intentional homicide, does acts towards the commission of that crime which demonstrate unequivocally, under all of the circumstances, that he had formed the intent and would commit the crime except for the intervention of another person or some other extraneous factor. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 2 elements were present for each count. Number 1, the defendant intended to kill John J. Miller and Rebecca Borkowski. Intended to kill means that the defendant had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. Number 2, the defendant did acts towards the commission of the crime of first-degree intentional homicide, which demonstrate unequivocally, under all of the circumstances, that the defendant intended to kill or would have killed John J. Miller and Rebecca Borkowski, except for the intervention of another person or some other extraneous factor. Unequivocally means that no other interference or conclusion can reasonably and fairly be drawn from the defendant's acts under the circumstances. Another person means any person but the defendant and may include the intended victim. An extenuating circumstances or factor is something outside the knowledge of the defendant or outside the control of the defendant. While the law requires the defendant act with intent to kill, it does not require that the intent existed for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, day, hour, or even a minute. There need not be any appreciable time before the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all of the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary for conviction, proof of motive is not. Motive refers to a person's reason for doing something. Motive may be shown as circumstance to aid in establishing the guilt of the defendant. The state is not required to prove motive on the part of the defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight that you believe it deserves under all of the circumstances. Once again, self-defense is an issue with respect to these counts also. The law of self-defense allows a defendant to threaten to use force against another only if the defendant believes that there is actual or imminent unlawful interference with the defendant's person, and the defendant believed that the amount of force the defendant used to threaten or to use was necessary to prevent or terminate the interference, and 3, that the defendant's belief was reasonable. The defendant may intentionally use force which is intended or likely to cause death or great bodily harm only if the defendant reasonably believed that the force used was necessary to prevent imminent death or bodily injury to himself or great bodily harm to himself. The belief may be reasonable, although mistaken. In determining whether the defendant's belief was reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances as they existed at the time of the alleged offense. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of the defendant's acts and not from the viewpoint of the jury now. The state must prove by evidence that satisfies you beyond a reasonable doubt that the defendant did not lawfully act in self-defense. If you are satisfied beyond a reasonable doubt that both elements of attempted first-degree intentional homicide have been proven and the defendant has not lawfully acted in self-defense, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with commission of an offense to be innocent. This presumption requires a finding of not guilty unless in your deliberations you find it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you may return a verdict of guilty, the evidence must satisfy beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you should do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which may be based upon mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth. And information is nothing more than a written formal accusation against the defendant charging the commission of one or more criminal acts. You are not to consider it as evidence against the defendant in any way. It does not arise any inference of guilt. Evidence is, first, the sworn testimony of the witnesses both on direct and cross-examination regardless of who called the witness. Second, the exhibits the court has received, whether or not the exhibit goes to the jury room. Third, any facts which the lawyers or parties have stipulated or agreed or which the court has directed you to find. Anything you may have seen or heard outside this courtroom is not evidence. You are to decide this case based solely on the evidence offered and received at trial. It is not necessary that every fact be proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Any type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy beyond a reasonable doubt that the defendant committed the offense before you may find the defendant guilty. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experiences in the affairs of life. Remarks of the attorneys are not evidence. If remarks suggest certain facts, not an evidence, disregard the suggestion. Consider carefully the closing arguments of the attorneys, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given to you by the court. An exhibit becomes evidence only when received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received is evidence, whether or not it goes to the jury room. Attorneys for each side have a right and a duty to object to what they consider are improper questions asked of the witness or witnesses and to the admission of other evidence which they believe is not properly admissible. Do not draw any conclusion from the fact that an objection was made. By allowing testimony or other evidence to be received over the objection, the court is not indicating any opinion about the evidence. You jurors are the judges of the credibility of the witnesses and the weight to be given to the evidence. Disregard entirely any questions that the court did not allow to be answered. Do not guess at what the witness's answer might have been. If the question itself suggested that certain facts might be true, ignore the suggestion and do not consider it as evidence. Evidence has been presented relating to the defendant's conduct after the alleged crime was committed. Whether the evidence shows a consciousness of guilt and whether consciousness of guilt shows actual guilt are matters exclusively for you to decide. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of the defendant, the state is not required to prove motive on the part of the defendant in order to convict. Evidence of motive does not, by itself, establish guilt. You should give it the weight that you believe it deserves under all of the circumstances. The weight of the evidence does not depend on the number of witnesses for each side. You may find that the testimony of one witness is entitled to greater weight than that of another witness or even several other witnesses. It is the duty of the jury to scrutinize and to weigh the testimony of the witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is the believability of the witnesses and the weight to be given to their testimony. In determining the credibility of each witness and the weight to be given to the testimony of each witness, consider these factors. Whether the witness has an interest or lack of interest in the result of this trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness of the witness's recollections, the opportunity the witness had for observing and knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, Bias or prejudice, if any, has been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend to either support or to discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. The defendant has testified in this case, and you should not discredit the testimony just because the defendant is charged with a crime. Use the same factors to determine the credibility and the weight of the defendant's testimony that you use to evaluate the testimony of any other witness. There is no magic way for you to evaluate testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourself the reliability of things people say to you. You should do the same thing here. Ordinarily, a witness may testify only about facts. However, a witness with a specialized knowledge in a particular field may give an opinion in that field. In determining the weight to be given to this opinion, you should consider the qualifications and credibility of the witness, the facts upon which the opinion is based, and the reason given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you were not bound by the witness's opinion. Evidence has been received that one of the witnesses in this trial has been convicted of crimes. This evidence was received solely because it bears upon the credibility of the witness. It must not be used for any other purpose. Evidence has been received that the defendant, Joshua W. Aide, has been convicted of a crime. This evidence was received solely because it bears upon the credibility of the defendant as a witness. It must not be used for any other purpose, and particularly you should bear in mind that a criminal conviction at some previous time is not proof of guilt of the offense now charged. We will now start with Ms. Nash's closing arguments. Ladies and gentlemen, you do get a copy of these instructions to take with you. I usually say that at the beginning, and I looked up once during the instructions and I got the deer and headlights look from you. Don't worry, you get these to take with you. Hold on a second, let me get you.
Thank you. Ladies and gentlemen, you heard Rebecca Borkowski and John Miller testify. You saw their demeanor both immediately after the shooting as well as on the stand at trial. Both Rebecca and John testified that the defendant, Joshua Aide, showed up at Rebecca's home and almost immediately began shooting them. They said it at the scene, they said it at the hospital, and they said it at this trial. Their statements have been consistent and credible. Everything they testified to is supported by the evidence you saw in this case. All three of Rebecca's neighbors testified to a quick succession of popping sounds. All three of Rebecca's neighbors testified that they heard no disturbance prior to hearing that popping sound. Ryan Garrod Johnson is so close to Rebecca's home that she shares a driveway with Rebecca. She testified that she was in a room on the southwest side of her home. She testified that she could hear Rebecca playing music as Rebecca and her guests were outside. Ryan heard no disturbance in that driveway prior to the pop-pop sound that drew her to the window, where she then saw the defendant standing behind the white car in the driveway. Both Rebecca and John have been completely cooperative at all stages of this investigation. John Miller provided a map of where he and Rebecca were standing when the defendant walked up to them that night. His map also shows you where the defendant was standing when he fired the Ruger 380 at Rebecca's head. Both John and Rebecca have testified to those locations, and their testimony has been consistent. Rebecca's wound to the right side of her head and the pool of blood from where she fell in the garage is consistent with both Rebecca and John's testimony. She was facing the Tahoe. She testified the defendant's gun failed to fire initially, and she turned to get away. She was shot in the right side of the head. The map also shows John Miller's path of travel. That's his path of travel there as he fled the defendant, going from the back of the car, around the front, through the neighbors' yards, ultimately to Dan Schrader's residence, where he burst in and asked Dan to call 911. The location of the bullet jacket in the concrete seam on the northwest corner of Rebecca's home indicates that the defendant, while standing where John had drawn that X, fired at John as he fled around the white car. That's also consistent with where he was standing, according to what Ryan Garrod Johnson testified to, that when she looked out her window upon hearing that pop pop sound, she saw the defendant standing behind the white car. Now, we know that jacket is the jacket from the bullet that went through the right side of John's face and out the left side. We know that because the other two bullets were lodged in the heads of the other two victims. That was the one bullet that passed through a victim. When we look at the next shot, this is also consistent. This is a still shot from the video you saw that Detective Robertson had taken the day after the incident. This would be from approximately the position that the defendant was standing when he traced John around the vehicle and shot him as he was coming around the corner of that vehicle. And that's how the bullet jacket ended up in that scene there. John testified that he was shot in the right side of his face. We could just go back to the last one. John testified that he was shot in the right side of his face with a bullet exiting the left side. Again, this is consistent with him coming around this car on this path, being shot in the right side of the face with a bullet exiting to the left. That is also consistent with the exhibit you heard John read, which is his certified medical records, indicating the bullet entered the right side of his face and exited the left side. The blood droplets in Rebecca's grass and on her neighbor's driveway also support John's statement of the path he took in search of help. All those blood droplets came back to John. Now, looking at this picture here and what the defendant testified to, it doesn't make any sense. So, he's testifying, defendant testified that he's about where the X is. John is up there, kind of where the J is, when he comes running this way and is already in a path of travel. If you were to take the defendant's version as true, John would have had to have been shot in the left side of the face as he's running this way. That's not what happened. That's not what his medical records say. That's not what he testified to. This is what matches the evidence on the scene. The other thing that doesn't add up about the defendant's statement is that this gun that Rebecca allegedly had was just tossed under a table in the garage. Now, you saw Rebecca's condition when officers came upon her in the garage. She was in no condition to run around hiding weapons, coming up with a scheme with John as he was running around somewhere else. That's simply not credible. She was so confused, she couldn't even identify where and what exactly her injury was. You saw her struggle to get up. You saw her waver as an officer tried to walk her out onto the driveway. It's simply not credible that Rebecca had the capacity, after being shot in the head by the defendant, to run around hiding weapons in the garage. The fact that there was no weapon on Rebecca is also consistent with what the detectives testified to. They thoroughly searched that garage. They were looking for the casing that at the time they got there was under the toolbox. They were also looking for the bullet that had gone through John Miller's face. They searched that garage thoroughly. There was no weapon located in the garage. And all of Rebecca's guns are accounted for as being inside the home. She has 5. 4 were located during the search. The 5th was located by her aunt. Her aunt is completely credible. Her reason for being in the home is completely legitimate and understandable given the condition Rebecca was in while still in the hospital. There is simply no evidence that Rebecca had a gun on her or threatened the defendant in any way. Now, regarding the defendant's intent, both John and Rebecca testified to the defendant pointing his .380 Ruger laser at their foreheads. The defendant intended to kill them. Regardless of what he wants you to believe about how this could have just been a coincidence or his laser wasn't working right or whatever he wants to argue about how this coincidence happened, you need to consider that all of these victims were shot in the head with a Ruger pistol with a laser. He intended to kill them. But for Rebecca's ability to turn quickly when the gun didn't initially fire, and the subsequent path of the bullet in her head, the defendant would likely have succeeded in his goal of killing her. But for John's quick decision to flee and the subsequent path of the bullet going through his mouth, the defendant would likely have succeeded in killing him as well. The defendant did succeed in his intentional killing of James Gruettner. James's gunshot wound was to the left side of his head, with the bullet traveling at a downward trajectory to the other side of his skull. This is also consistent with James being shot by the defendant as he was standing next to the white vehicle in the driveway, as John had testified to. Now, the defendant's version of events regarding what happened with James is just not credible either. That James was silently attacking him such that the neighbor wouldn't be able to hear it, and James was repeatedly pushing him, and then rather than running away or leaving the scene or even yelling for help, the defendant, a 20-year Marine veteran who was 39 years old at the time, is so afraid of this older man with a back injury that he feels that he has to shoot him in the head. That is just not believable. The 3 casings and 1 bullet jacket on the scene came back to the Ruger .380 located in Joshua's pocket when he was taken into custody. The bullet removed from Rebecca's head and the bullet removed from James Gruettner's head also came back to the Ruger .380 located in Joshua's pocket. Rebecca and John have provided consistent and credible testimony. They provided consistent accounts immediately after being located separately by officers. They had no opportunity to discuss anything that would be said to officers prior to their arrival. John reports he fled immediately, got a neighbor to call 911. He ran back and said to James and Rebecca, "Help is on the way." He reported he didn't talk to Rebecca. She was in the garage moaning. He testified that he could tell James was deceased. And again, all he heard from Rebecca was her moaning. Rebecca and John did not talk about this prior to officers' arrival. And you saw Rebecca's condition. It is again not credible that she was coordinating a story with John and trying to stage a crime scene while suffering from a gunshot wound to the head. The statements of John and Rebecca are so similar, even though taken apart, that they both mentioned the defendant saying, "Hey," to Rebecca as he walked toward her. Rebecca indicated that the defendant said, "Hey, boo," as he walked toward her. John believed the defendant had said, "Hey, babe." Again, they are located separately, but that detail is also the same. The locations they were at were the same. And their testimony has been consistent. It has been the defendant arrived and almost immediately began shooting at them. Both of them, when they were with officers that night, asked officers to check on other people. Rebecca wanted officers to check on Samantha because she was afraid for Samantha's safety. John was spontaneously concerned about his girlfriend's safety and Julie's safety, worried because the defendant knew where they were. They were scared because they were the victims and they were worried about what the defendant was going to do next because of what he'd just done to them. Neither Rebecca nor John have any reason to lie about what happened that night. John had only met Rebecca a few hours before he was shot in the face. He would have had no reason to get into a fist fight for Rebecca or her father. And he was meeting James for the first time that weekend as well. Rebecca has no reason to lie about what happened. The evidence has shown that she was on her own property with her own guests, engaging in fixing a vehicle she co-owned when the defendant showed up uninvited, drunk, and armed with a pistol in his pocket and a loaded revolver in his vehicle. Rebecca was unarmed and defenseless against the defendant's loaded .380 Ruger, and it was equipped with a laser as well. All of Rebecca's firearms are accounted for as being inside her home that night. Rebecca simply had no access to them. There is no evidence to support the defendant's claim of a conspiracy to lure him into a gun battle so that someone could shoot him for insurance proceeds. That's just such a wild tale, it lacks any sort of credibility. You saw the Facebook Messenger exchange leading up to this. In spite of what the defendant wanted you to believe while he was on the stand, you read his messages. You saw him repeatedly try to get Rebecca to get back together with him. She repeatedly tells him no. He asks to come help with the Tahoe. She tells him no. You heard the text that Julie received from Rebecca. Rebecca told Julie in that text that she had told the defendant if he comes to her property, police will be called. These are not people involved in a conspiracy to hurt the defendant. These are people who are scared of the defendant and want him to stay away from them. The only thing that Rebecca wanted was to finally end her relationship with Joshua Aide and return all of his property so that she could be done with him for good. The defendant was an abusive and controlling boyfriend. He could not accept that Rebecca had made the decision to leave him. That Tahoe and that property exchange represented to him a final end to their relationship. Rebecca intended to cut Joshua Aide out of her life. He could not accept that and reacted violently when Rebecca insisted that the property exchange happen that weekend. There is no evidence to support this self-defense claim. So let's walk through some of the things that we can verify through evidence. The defendant shot 3 people in the head with a weapon that was equipped with a laser. The defendant shot James Gruettner at a distance of at least 5 feet. You heard the medical examiner's testimony. He testified there was no evidence of close-range firing. The defendant would have you believe that James was right in the process of trying to punch him in the face, right up on him. Again, the medical examiner's testimony says no. At least 5 feet he shot him from. The defendant did not render aid to any of the victims after shooting them. Neighbor Ryan said that she locked eyes with the defendant. He didn't wave her down for help. He got in his car and fled the scene. He didn't call 911. The shooting was called into dispatch at 8:27 p.m. by Rebecca's neighbor. The first call shown on the defendant's call log after the shooting communicated with the cell tower in Waupun at 9:06 p.m. He made it from Oshkosh to Waupun in 40 minutes. Now he wants you to believe that he was the sober and rational party when he arrived at Rebecca's house that night. So he's got to explain what you saw in the Greene County video. You saw his condition. He was clearly intoxicated. So he wants to explain his intoxication by saying that he stopped in Fond du Lac, he got some gas, he washed his face, he bought a 6-pack of beer. He did all those things and still apparently made it from Oshkosh to Waupun in 40 minutes. That's not credible. What is credible is the defendant was completely wasted when he arrived at Rebecca's house, and that contributed to his actions that night. He wasn't the rational party. The victims were. Now, the defendant then gets a call from his friend, First Sergeant Peter Vargo, tells him he's just driving home from work. He's then stopped by Greene County deputies. He acts bewildered as to why officers would possibly be at his property. You saw him losing his balance, even stepping out of the vehicle. You heard his slow and slurred manner of speech. When Oshkosh officers made contact with him at the Oregon Police Department, he again denies any knowledge of what's going on here. So as we move forward in this case, he asks his friend Lee to come up with a story about Rebecca to support his self-defense claim and to make it sound good, like he saw the whole thing. None of those actions that I just described are consistent with Joshua Aide being the victim in all this. Those actions indicate that he was a man trying to flee the scene of an intentional crime and ultimately trying to avoid responsibility for a homicide and 2 attempted homicides. Although the state's not required to prove motive, it has been thoroughly established in this case. You've seen evidence of what motivated the defendant in this shooting. He wanted to control Rebecca. He wanted to control her decision to leave the relationship. He wanted to control who came to her house. He even wanted to control how she handled a minor repair on a vehicle she was co-owner of. Again, that vehicle was the final step to Rebecca cutting the defendant out of her life for good, and he would not accept that. Again, the defendant's story is not supported by the evidence. It does not make any sense. And just like he asked Lee Hilgendorf to do, he is now making up a story about Rebecca. So the timeline provides some more information for you to consider, and I know it's hard to listen to our witnesses just go through numbers, so hoping to walk you through this a little bit more. 2:41 p.m., defendant calls John Miller telling him not to come to Rebecca's house. Then he calls Rebecca 2 times shortly after that. Rebecca calls him back at 3 o'clock p.m. 3:18, there's that final text that Rebecca accidentally sends the defendant, her address. Now, there is no reason that the defendant would have believed that to be an invitation to come to her house. He knows where she lives. She'd been telling him all day she doesn't want him. 3:18, Rebecca then says the correction text to her father. Same text sent to her dad immediately after. So it was not a conspiracy by Rebecca to lure the defendant to her house. It was an accidental text sent, a common mistake. 4:06 p.m., Rebecca texts Julie that she told the defendant police will be called if he comes. Again, that's Rebecca and Julie talking about not wanting the defendant at her house. There was no conspiracy to get him there. 4:18 p.m. Defendant sends final Facebook message, don't touch the radiator. 4:34 p.m. Defendant texts Balthazar, Becky is really pissing me off right now. 2 calls made. First, Rebecca calls the defendant, 8-minute call. Then defendant calls Rebecca, 4-minute call. Then he calls her 3 more times, they go unanswered. He calls her again at 5:08, she answers. 2 more calls to her unanswered, and then they talk again at 5:11 p.m. and 5:29 p.m. is the last call. Now as we move forward from there, these are all the calls where the defendant is repeatedly calling Rebecca. He calls her 31 times in an hour and a half. That's not someone driving along thinking, I want to help you out and maybe pick something up for you. That is obsessive, controlling, outrageous behavior. He was mad. So we get through 31 calls that were made to Rebecca that all went unanswered. We can see that as he's making those 31 calls, on our map, you saw him driving up to the Oshkosh area. Last call to Rebecca, 8:05 p.m., a Fond du Lac cell tower communication. She doesn't answer. 8:27 p.m., Dan Schrader's 911 call comes in. That tells us 22 minutes this man got from Fond du Lac to Oshkosh and completed a shooting in the head of 3 people. That was after calling Rebecca's phone every 3 minutes on his drive up to Oshkosh where he was coming uninvited. That behavior shows someone who was mad, someone who had a plan. 22 minutes, and they were all shot in the head. Now when we talk about the way back, we addressed this a little bit, but no call for help, no assistance to the victims. He knows they all have gunshot wounds to the head. His next call is to his friend, Lee Hilgendorf. Same guy that you hear him on jail calls asking to lie about Rebecca. Maybe someone he trusts in this kind of situation. That's Waupun Tower communication. So 8:27, 911 call comes in. He has booked it back to Waupun by 9:06 p.m. And he wants you to believe that he found the time in there to buy some beer, get some gas, wash his face, so that he can explain why he was so impaired when you saw him when Greene County deputies located him. So the defense has presented this elaborate conspiracy theory where James, the deceased, Julie, Rebecca, and John are all in on this plot to get the defendant into a gun battle so they can get his insurance money. It makes no sense. And it makes no sense because that's not what happened. Now, I'm going to ask you to consider what was going on when the nurse thought she understood what Julie had told her. Nurse calls Julie to tell Julie that her daughter has been shot. Nurse testified that Julie was frantic. The nurse also testified that it's possible she misunderstood what Julie meant. That is what makes sense with what that nurse testified to. There is no indication that Julie ever told anyone that her husband had intended to kill anyone. Julie has been participating in this case. She testified today. She was credible. What she said made sense. She indicated that she did not, I believe she said absolutely not, make that statement to that nurse. Now, Julie's question, what the nurse talked about her daughter being shot, well, we see what's going on from those text messages and what Julie testified to. Julie is sending Rebecca a text saying, stop talking to him. Why did you tell him that they were going to be there? She is scared. She's talking about having a police escort to go and even return the defendant's property. This is someone who knows that the defendant is dangerous. That accounts for the statement she made. The nurse misunderstood what she was talking about. Julie's husband was driving to Oshkosh. That's true. The defendant drove to Oshkosh and shot Julie's daughter in the head. Now, to try to turn a nurse's misunderstanding of what a frantic mother was saying during a phone call where she's learning her daughter's shot in the head, to try to spin that into a conspiracy where now Julie's in on this plan to grab the defendant's insurance through a gun battle with him is just beyond the realm of reasonable. What happened here is the defendant was motivated by anger, jealousy, and a desire to control Rebecca. That explains getting in his car to drive 2.5 hours uninvited to Rebecca's house. That explains calling her 31 times over an 1.5-hour period. That explains 3 shots in rapid succession, and that explains his flight back home. This was an intentional act driven by anger, jealousy, and rage. And I'm asking you to find the defendant guilty of all 3 counts charged.
Mr. Seaman.
Thank you, Your Honor. And if it's all right, I'll remain seated so I can access my computer if the court needs to know.
It's fine. If you need to get on, let me know.
Will do, thank you. Thank you, ladies and gentlemen, for your attention on this case. Now, the state gets another closing statement called a rebuttal. The defense does not. That's the way our system is set up because they have the burden. So this will be my only chance to talk to you. And what I want to, I think, focus on and what the evidence has showed in this case is that within a couple hours of the shooting, approximately, Joshua Aide was in custody, and detectives from the Oshkosh Police Department had traveled down to the city of Oregon, placed him under arrest, and essentially at that point, as far as law enforcement was concerned, this case was essentially closed. You had heard Detective Artis' testimony, you had heard the audio, you told him you were being charged, 1 count of first-degree intentional homicide, 2 counts of attempted homicide. I'm not going to give you the honor and privilege, or the pleasure and privilege of knowing who it was you killed. I mean, the decision was made and the investigation was essentially over that night within a couple hours on what really turned out to be a rather complicated case. And what this was And what the evidence is showing here is the only continued investigation really by law enforcement was a somewhat coordinated effort to make the evidence in this case fix the narrative that was given by their determined victims, Rebecca Borkowski and John Miller. For example, John Miller's statement. The first statement, the statement that he gave that night in the hospital was that he was standing in front of the Tahoe's radiator when Josh came up, and that is where Josh had shot him. And then he gave a later statement through that exhibit that you were shown just in closing arguments by the state on that photograph where he had drawn like the footsteps or he'd marked with a marker his route. Well, that's because 10 days later, after approximately, I believe it was August 14th, they had discovered, Detective Robinson had discovered this bullet jacket down in a crack in the cement at Rebecca Borkowski's driveway. Now, 10 days later, this is after the driveway had been scrubbed clean, vehicles moved out, numerous personnel in and out of there. Apparently, Sharon Mariano had cleaned the driveway, scrubbed it, conceivably swept it. The state and the police just landed on that must be in that crack where this bullet jacket flew and landed. And instead of even considering that this bullet jacket was probably swept into that crack when the cement was cleaned, it almost seems obvious, but instead, as Detective Hinkie said, something to the effect of John Miller's statements just wasn't making sense. Well, why wasn't it making sense? Because it wasn't true. It was even inconsistent, the first version with Rebecca, when he said that he was standing in front of the Tahoe and Rebecca was standing over by the passenger side wheel well, where Rebecca said they were both standing together in front of the Tahoe. Why don't they match? Because neither one of them is actually true. The second example that we saw in the course of the trial of law enforcement taking the evidence in this case, or attempting to make it fit the narrative of Rebecca and John, was from Officer Cody Rucan. And they're in evidence as his two police reports that he, for some reason, wrote in this case, specifically the second one. His first police report, this is Defense Exhibit 22, and he testified about it that it reflected that Rebecca responded to verbal commands when he first had contact with her. Then in December, he filed a second police report that said she was unconscious and unresponsive. Well, we know from the initial arriving officer that got there before Cody Rucan that she was in fact conscious and responsive and answering the officers as they called out to her. The first report, he talked about looking through her hair for a gunshot wound. The second report, he searched the area around her person for weapons and evidence that could have been ditched or placed near her. That first report was written on August 5th, 2020, the second, December 19th, 2020. Well, what happened in between that time frame? Rebecca had showed up with this missing firearm. And when I asked the officer, who told you to write this second report, to essentially change this narrative, never did get a clear answer out of that. Multiple searches, multiple officers searched through, pursuant to a search warrant, trained officers, trained in conducting searches, searched through Rebecca Borkowski's house that night, and they found 4 weapons, looking for weapons and other evidence of a crime, and they found 4 of them. And yet, after Rebecca turns over her .380, there was really no explanation. I think it even went as far as Detective Fry said he wasn't sure if anybody even searched that room, the living room. Detective Robertson testified he knows there was officers searching the downstairs, he was upstairs, and his impressions of the search that they were doing a thorough search. Now, you saw Officer Nick Kowalski's body camera when he was in there looking for the dog. He had approached, as he was walking around looking for the dog, pretty much instinctively what police officers do. I just think it's in their DNA and in their training to look under things, to look for things. And he moved the pillow aside, and the bag opened up, and I asked him, were you able to look in there? And he confirmed he did, and he saw nothing. Despite how the state tried to spin it on cross-examination and get him to speculate, did you see anything in that bag that was relevant? He said no. Had you seen a gun? Is that something you would have reported? Yes. So, where did Rebecca's gun go that night? And I told you, there's going to be some answers some questions that we can't answer, and the burden is not on us to answer them. And one reason why we don't know is nobody bothered to investigate or even question what happened to this other gun. We know from the body cam of Officer Scott, the responding officer, that when he arrived, and you could see John Miller running back from across the street. He wasn't kneeling in the road, he wasn't coming down the sidewalk, he was running across the street. Where was he coming from? We don't know. Did he run back to the scene after going to Daniel Schrader's house and pick up the gun and take it across the road? We don't know. Was it looked into? No. Did anybody look for blood droplets out in the streets? Well, certainly there would have been. And where they led to? No. Said nobody was interested in investigating anything further that didn't fit the narrative that was already provided by John Miller and Rebecca Borkowski. Nobody asked John Miller where he was coming from the other side of the road. John Miller testified, well, you saw on cross-examination in the video, John Miller, with 13 prior criminal convictions, had told the police on August 4th that he had just met those people yesterday. You saw that on the video, which would have been August 3rd. He told Detective Hinkey later, and she testified, and I asked her about, that he had been friends with these people for years. Why lie? What are you covering up? Two different versions he gave of where he was shot, both differ, and regarding where Rebecca Borkowski says she was standing. What we do know about John Miller, and that came out in my questioning Julie Gruettner, was that he became upset when Joshua Aide called him on the 4th and was questioning his credentials. And we know later, after that phone call, as he apparently sat and stewed on Josh Aide's audacity, he became, quote, royally pissed off, end quote. And what did, at that point, was that when the decision was made to go down that day and lure Josh down there and kill him? We don't know. Again, this wasn't thoroughly investigated, but we know the evidence is showing that as that afternoon went on, John Miller is the one that got royally pissed off, became extremely upset. We're not asking you to speculate that or infer that from anything. You were provided that testimony. And at some point after that, it appears that the decision was made to have Rebecca call Josh and tell him that they were going to be changing the radiator that day. One that Josh, that you now know, repeatedly asked her not to do. If not, allow him to come and pick it up and do it, to have a certified mechanic do it. That was done through a phone call. They texted him the address. And at some point then they proceeded down up to Oshkosh. And John Miller acknowledged that he had a knife. And this was to repair a radiator that apparently had a hairline crack in it that hadn't been a problem since it was discovered in November of 2019. So knowing that Josh Aide did not want him doing this, yet they decided that day, after they were all quite upset, John Miller clearly, was upset, they lured him up there under that auspice. And we know Rebecca strategically placed firearms around her property. We saw her text message to that effect as well. We know that from her testimony, she put her cell phone in her Jeep after they had arrived at her residence, and that she kept in her vehicle that Oshkosh defense bag that she had carried, inside that bag, she had items from her car. And inside that bag was located by the officers a Smith & Wesson magazine and the ammunition. That's where she kept that Smith & Wesson .380 pistol that was missing from the scene and then later turned in after apparently first asking if she could get the other guns back. And this gun that she acknowledged in her testimony, forgetting to initially tell the police about. Though she offered up at first that it was a Ruger, but in fact now we know it was a Smith & Wesson. So how does Sharon Morgano fit in all this? You saw her testimony. I mean, she clearly appeared uncomfortable. There's no doubt about that, and I have no doubt she was anything other than a pawn in this. However, she said she found the gun in a place where we know law enforcement officers looked, if not once, certainly by Officer Koleski twice during the search of the residence, and it was not there. But she said she found it while she was looking for Rebecca's wallet. But on cross-examination, she acknowledged that Rebecca didn't know she was there and couldn't say who, if anybody, had asked her to go get her wallet. So that doesn't make any sense. The state asks you to believe that it's improbable that Josh could have shot John Miller on the right side of his face as he's facing him, but they forget that Josh is left-handed. And instead they ask you to believe him that he shot him from behind as he's coming around chasing him, in their words, around the Ford Focus. But that still doesn't make any sense. He'd be shot in the back of the head, and it still doesn't put the casing landing on its own where they wanted to have landed in that crack in the cement, approximately 10 days after there had been thorough cleaning of that property. It's the first time I don't think there's any evidence other than an argument's not evidence, but the state said that Josh chased John Miller around the vehicle and shot him. Nothing supports that. As to evidence of intent, really what the state offers, it makes no sense at all. Josh is just before this, retired from the Marine Corps, successfully employed as an engineer, honored the discharge from the Corps, employed as an engineer. He had really no appreciable contact with Rebecca since their breakup in March. Months had gone on. All he wanted to do was maintain some type of friendly relations with her, months without any issues whatsoever. But we do know. I mean, so that leaves the question, well, what's the motive on either side? Because it makes no sense at all that Josh would just drive up there and shoot these three in the head and leave. And the state attacks our motive for why they would want to, Rebecca, John, and Jim, lure Josh up there to kill him. Well, we do know that Rebecca was a beneficiary on his life insurance policy, as well as his work. But again, the state failed, or the law enforcement absolutely failed to look into any of this and thoroughly investigate this case, but more importantly, whether you want to, and if I could have the counsel, please. Whether you want to say it was just sloppy police work regarding the searches, Detective Fry, I believe it was, that said that they couldn't even confirm if somebody had searched inside the recycle bin or the garbage bin or not. There's absolutely nothing sloppy about the absolute failure to even look into Nurse Nikki's statement to law enforcement at the hospital that night. The only thing that they gathered from it is that this was just buried. And playing defense exhibit number 19 from the admitted portion beginning at 3:25.
So basically, Dad,
Take the pill. No, I just got off the phone with Mom.
so when did you guys hear that story?
So I just got off the phone with her mom. And there's a
Holy shit.
She just got off the phone with Mom.
So it must have went through the ears.
Wow.
I've seen them where they hit the skull, they don't go in, and they just hit the skies in the back. So she's tender right about here.
Yeah.
She's swollen.
There was just someone. So, you couldn't even find it.
We got off the phone with Mom. She wanted me to. She immediately started crying. She read, she got. Hi, my name is Nikki. I'm a nurse. Like, she started freaking out. I'm like, wait. I said, I have your dog here. She was shocked. I'm like, I haven't told her anything yet. And she goes, I said, no, she's here. You know, I'm looking after him, did her die. And right away, she's like, yeah, him did her die. She said, where's my husband? I said, I don't know who your husband is. Well, my husband was on his way out. I was going to kill someone.
I don't know.
He didn't. I found that out, but I told her and I didn't tell the mom. So, I don't know what all transpired. I told her. I know you looked at the scene, and she said, my husband, another in-law was there, for like best friend, was there.
It's a family friend, and that's who's at dinner.
Okay, so,
It's his family friend.
yes, she said, my girlfriend's husband, and my husband were on their way there to kill
John and Jim must have went.
Stopping at 5 minutes, 16 seconds. No matter how the district attorney tried to throw Nurse Nikki, she finally responded, I know what I heard. And it's unequivocal that Julie, after being initially told that Rebecca is in the hospital, her first reaction was she shot? Not was she in an accident or anything like that. And then she unequivocally said her husband and her girlfriend's husband, John, were on their way to Oshkosh to kill him. There is no getting around that. There is no excuse for when the nurse testified that she told these officers, including the tall, skinny detective at the hospital that night, that absolutely nothing was done about this. No questions were ever asked of Julie. No questions were ever asked of Rebecca. No questions were ever asked of John. And this circles back around to the start of my closing argument, that the only work that was done in this case by law enforcement was to cram everything into the narrative that they had been provided by the people that they deemed the victims. Period. Up to this point, nobody would listen to Nurse Nicole Fields. Thank God you are here today, and that we ask that you will. Up to today, nobody cared about anything that Nurse Nicole Fields had to say, at all. We ask today that you do. The states tried to do everything they could to distract from this, to keep you from hearing it. They want you to look over here back to 2016 to 2018 and text messages and Josh is an abuser and all of this. But nothing can distract you from Nurse Nicole's testimony and the unimpeachable truth that Jim Gruettner and John Miller drove to Oshkosh that night to kill Joshua Aide. And the only thing that fits the evidence that makes any sense whatsoever is Joshua Aide walked into an ambush. And the only thing that I stated in my opening statement that Joshua Aide is guilty of is being the survivor. That is why he's not law enforcement's designated victim. And I ask that you find him not guilty. Thank you.
Next.
Thank you. If we could just get this, the screen. Now, I just want to clarify, in case any of you were confused, because I think the defense is confused. The state is not arguing that the defendant chased John Miller around a car. I'm arguing there was the defendant where the X was, John was where the J was. As John stated, the laser gets trained at his head when he's standing there immediately after Rebecca's shot. John runs. The defendant stays there. Laser on John as he comes around that vehicle. He is shot, and the bullet goes through the right side of his face, out the left side. And if we move on, let's go to the next one first. Thank you. That is a view of where the defendant would have been standing as he trained his gun on John as he came around and shot John in the face. That explains how the jacket got there. I'm going back to the other one. The other side. Yeah. So again, John is shot in the right side of the face and out the left side of the face. John testified to it. His medical records support it. So if we go back to that map again. The defendant's version just cannot be true, because what he testified to was that John was in the path of running toward him and kept running when he was shot in the face. That would mean John would have had to have been shot in the left side of the face. No evidence supports that. John's injury doesn't support that. Now, to believe the defendant's version of events, you've got to believe in a whole lot of conspiracies. You've got to believe that Rebecca and her family were conspiring to get into a gun battle for insurance money. That's the first conspiracy. Then you have to believe that their means, that Rebecca's means of getting the defendant to come over is to repeatedly tell him, leave me alone. That doesn't make any sense. She didn't want him there. She wasn't luring him anywhere. She wanted to be done with him. Then you have to believe this story that there was a gun laying under this table that somehow disappeared. The defendant claims he saw it, fell out of her hand, laying under a table in the garage. There's no evidence Rebecca ever left that garage. Officers found her. You saw the pool of blood from where she was lying. The blood droplets in the driveway don't come back to her. There's no evidence that John Miller re-entered the garage. Had John entered the garage and crawled under a table, we would expect to see blood droplets from him. You saw how the neighboring driveways looked when he ran through. There was blood droplets all over. He was really bleeding. There was no blood leading into the garage, no other blood droplets. There was Rebecca's blood in the garage, no evidence she'd gone anywhere else, and John's blood was in the yard and the neighboring properties. The guns are accounted for. If Rebecca and her family are engaged in this big conspiracy, why on earth would Rebecca be the one to bring that to officers' attention? Rebecca asked officers if her guns could be released to her. They're hers, it's understandable. When they tell her no, and that they're keeping them as part of this case, she volunteers that information to officers. She says, hey, you missed one. She brings it to the police department. She wasn't hiding anything. This just didn't occur to her that this was an issue. Detective Robertson even testified that when he was in the hospital on August 5th, the day after the shooting, she discussed her Smith & Wesson 380 then. She discussed it with him again when he was back at the hospital on the 11th. She has not tried to hide a single thing. She's been open about everything. Officers have testified that both Rebecca and John have been fully cooperative in this case. They have provided everything asked of them, answered every question asked of them. I think the defense is mischaracterizing Detective Hinkey's testimony regarding John. She never said that John was inconsistent. The defense wants to grasp at straws by trying to get you to believe that this nurse's statement is something more than the obvious, that the nurse misunderstood what a frantic mother was saying when she was learning that her daughter was shot in the head. There's already some confusion, even if the nurse thinks she remembers exactly what was said. Julie's friend Carla isn't married to John. She testified it's her boyfriend. They've been dating 8 months. So maybe Julie mentioned husband somewhere in this statement, but it certainly wouldn't be with regard to the friend that was driving there, because he wasn't anyone's husband. He's not married to Carla. So I think the obvious explanation is the explanation. Like I said, frantic mother, a nurse giving her the news about what happened to her daughter, and a nurse misunderstanding what was said. She even testified that it's possible that she misunderstood, and that's what happened. Now, the judge gave you an instruction that you're not to search for doubt, you're to search for the truth. And there are two very different versions of what happened here. But again, all of the evidence, all of the defendant's actions, they all support that this was an intentional homicide and attempted homicides motivated by anger, jealousy, and a desire to control Rebecca and to remain in the relationship with her. You saw those Facebook messages. You saw him again and again and again try to get back with her. You saw her say no, no, no. She didn't want him there that day. No one lured him there. He went there out of anger. He went there because he was mad she was defying him. I think the evidence speaks for itself. The state has presented all of the evidence expected to be presented to you in this case, and I do believe the evidence is certainly sufficient to find the defendant guilty as to all counts, and I would ask you to return verdicts of guilty as to each of the 3 counts. Thank you.
Now, members of the jury, the duty of counsel in the court has been performed. The case has been argued by counsel. The court has instructed you regarding the rules of law which should govern you in your deliberations. Time has now come when the great burden of reaching a just, fair, and conscientious decision in this case to be thrown wholly upon you, the jurors selected for this important duty. You will not be swayed by sympathy, prejudice, or passion. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duties steadfastly minded as upright citizens, rendering a just and true verdict. You are to decide only whether the defendant is guilty or not guilty of the offense. Any consequences of your verdict are matters for the court alone to decide and must not affect your deliberations. The following 6 forms of verdict will be submitted to you concerning the charges against the defendant, Joshua Aide. Count 1 reading, we the jury find the defendant Joshua W. Aide guilty of first-degree intentional homicide as charged in count 1 of the information. A second one reading, we the jury find the defendant Joshua W. Aide not guilty of first-degree intentional homicide as charged in count 1 of the information. With respect to count 2, a third reading, we the jury find the defendant Joshua W. Aide guilty of attempted first-degree intentional homicide as charged in count 2 of the information. And a fourth reading, we the jury find the defendant Joshua W. Aide not guilty of attempted first-degree intentional homicide as charged in count 2 of the information. With respect to count 3, a fifth reading, we the jury find the defendant Joshua W. Aide guilty of attempted first-degree intentional homicide as charged in count 3 of the information. And a sixth reading, we the jury find the defendant Joshua W. Aide not guilty of attempted first-degree intentional homicide as charged in count 3 of the information. It is for you to determine whether the defendant is guilty or not guilty of each of the offenses charged. You must make a finding as to each count of the information. Each count charges a separate crime, and you must consider each one separately. Your verdict for the crime charged in count 1 must not affect your verdict in any other count. This is a criminal case, not a civil case, and therefore before you may return a verdict of guilty, or which may be Mr. Over. This is a criminal case, not a civil case, and therefore before the jury may return a verdict which may be legally received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you arrive in the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other juror. When you need to communicate with the court, while you are deliberated, send a note through the bailiff signed by the presiding juror. To have a complete record of the trial, it is important that you communicate with the court only by a written note. If you have any questions, the court will talk with the attorneys before answering, and that may take some time. You should continue your deliberations while you're waiting for an answer. The court will answer the questions in writing or orally here in open court. When you have agreed upon your verdict, have it signed and dated by the person you have selected to preside. After you have reached your verdict, the presiding juror will notify the bailiff that a verdict has been reached. Everyone will return to the courtroom. The verdict will be read here in open court, and the court may ask you if you agree with the verdict. We will now swear in the bailiff. Let me get John in.
I'll get you. Do you swear that you will, to the utmost of your ability, keep all jurors sworn on this trial together in some private and convenient place, subject to the direction of the court until they have agreed on their verdict, or are discharged by the court, and that they will not, before they render their verdict, communicate to any person the state of their deliberations or the verdicts they have agreed upon, so help you God.
I do.
Thank you.
Yes, I swear.
Well, before we take the juries away, there's something we need to do. As you know, there are 13 of you, and 12 of you must agree. One of you has been my insurance policy. So, to make sure no one got sick. You put 13 numbers in there, she pulls out one, and that person will not be deliberating with the rest of you. If you want to know what happened, you can give your contact information to Mr. Zimmerman, and he can let you know when we're done. Please be seated. Anything we can put on the record before we recess from the state perspective?
No, Your Honor.
Depends?
No, sir.
Oh, I guess one thing, state would move in all exhibits to the extent that they haven't already been.
I think we've all none of that offered have been received.
And state's exhibit 7, all the items on the thumb drive.
Will be, I think I asked, and Mr. Seaman had no objection because he was talking to, I remember because he was talking to his client at that time, and he could hear me at the same time he was listening to his client. And then he said, no objection.
Thank you.
So accept and receive those exhibits. All right, if you're gonna be anywhere, let us know so we can contact the attorney and be back here within 5 minutes. Not to take verdict without, but in case of questions, we need to, if you want input into jury questions, you need to be here.
Thank you.
Stand recess until we hear from the jury.